Oh, let me find that. Let me see if I can remember what key that starts in. Oh, Andrew, that one's funny. Thank you. Um, let's see where to go. There it is. Okay, I think I do. I do that in the key of A. I had to remember a key. Everybody want to sing with me? I'm being swallowed by a boa constrictor. I'm being swallowed by a boa constrictor. I'm being swallowed by a boa constrictor, and I don't like it very much. Sing with me. Like you guys know the. Oh no, he swallowed my toe. He swallowed my toe. Oh gee, he's up to my knee. He's up to my knee. Oh fiddle, he's reached my middle. He's reached my middle. Oh heck, he's up to my neck. He's up to my neck. Oh dread, he swallowed my. Thanks for the request, Andrew. You too can make a request just like that. All you do is you type in your request into the chat window, and if I know it, I'll play it. You can look at my repertoire list, and find the songs I actually do if you want to get it right the first time. Cody's here. Hi, Cody. Nice to see you. We're playing a game. For those of you guys who just showed up, we're playing a game. It's called come on. I'm looking for one that we're going to do is this song right here. Are you ready? Say you're ready. And take a guess this time. Oops. Hold on. We're going to do this song. Here's your, get your fingers on the typewriter. You can tell what era I'm from. Put your fingers on that keyboard and ready to type. 1, 2, here's your song. Hi, Seth. Nice to see you. Puff the magic dragon lived by the sea. Hi, Jennifer. And frolicked in the autumn mist in a land called Honolulu. Little Jackie Paper.
What's up, people? You like my girl Lindy Moo? What's up, people? How we doing? Thought I'd change it up a little bit instead of the same old stale stuff going on. I don't know how she stumbled on into my feed, but I found her and she is lovely. Here we go, and a violin interlude in court. Thank you, my crazy. That was unbelievable. What's up, people? How we doing? Don't forget, Thursday is the Incredible Live Show with Mikey the Legend. What's up, people? Oh, it's TPO Tuesday. It is crazy, and it's going to be followed by our girl, Kitch. She's got even more TPOs. I got a crazy little brother fight, and I got a ton of clips today. Always a ton of clips. What's up, people? How we doing? As the regulars are trickling in, let's get rolling with clip number 1. Oh, how we doing, people? I just love being live. Let's do it. Oh, and I have such a surprise for you guys later. Oh, you're going to love it. Here we go. Let's have some fun. Let's get a little magistrate Judge Nelson. Is he a magistrate or a judge? I always forget. I love Nelson. Here we go.
1613A, 3B, and 22W001448. All right, taking these in order called.
What's up, Miss Fields? Everybody go sub to Miss Fields' channel. Make sure to sub
the first
to
alleged
Fields.
on August 15, 2022, Ypsilanti Township, Washtenaw County, State of Michigan, 771 Wood Creek
Exactly,
Court.
daylight.
You commit offensive larceny by stealing money belonging to Jeffrey Jones. A misdemeanor carrying a maximum penalty if convicted of up to 93 days in jail, a $500 fine plus court costs, or both. Do you understand that?
Hold on. So you said stealing what from Jeffrey Jones?
Money, cash.
Yeah. When this come through? When did this happen?
The allegations that occurred on August the 15th of last year.
Did I stole money from him?
That's the allegation. Yep. Okay.
Okay.
Next.
All right.
Next case, let's see here, alleges that on August 16th, 2022, Ypsilanti Township, Washtenaw County, State of Michigan, at 1172 Lexington Parkway, you did commit offensive larceny by stealing a puppy belonging to James Johnson, a misdemeanor carrying a maximum penalty if convicted of up to 93 days in jail, a $500 fine plus court costs, or both. Do you understand that?
He stole a puppy.
Yes.
Next case alleges that on October 14, 2022, Ypsilanti Township, Washtenaw County, State of Michigan,
What a thief.
at 1334 Holmes Road, you been offensive larceny by stealing a package belonging to Laura and McCrae, a misdemeanor carrying a maximum penalty if convicted of up to 93 days in jail, a $500 fine plus court costs, or both. You understand that?
What a klepto.
Yes.
Okay. The next one is a driving license suspended, was set for a pretrial hearing in April, if you failed to appear, and a bench warrant issued for your arrest. Do you understand that?
Yes. Understand.
And we have, let's see.
Oh, grim.
Operating while intoxicated, also set for April 5th, for which you failed to appear, and a bench warrant issued for your arrest in that matter as well. You understand that?
Yes, because I've been here with all my kids and stuff, Nelson. And my phone, I got at the phone. That's why I can get online. I had called that day when I had the court. I was on the phone with the people when I was at court, and they wouldn't let me. I couldn't get in.
All
You
right.
had the court.
For the new charges, were you able to review the advice of rights form online?
I don't think I did.
Okay. Court will advise your rights on the record. These are misdemeanor charges. You may plead guilty, not guilty, or stand mute to the charge. You have the right to trial by jury, the right to the assistance of an attorney. If you cannot afford an attorney, one will represent you at public expense. Should this matter go to trial, you have the following trial rights. You may see, hear, and question any witness against you. You may call witnesses to speak on your behalf. You have the right to be a witness for yourself or to remain silent. Should you choose not to testify, the prosecutor may not comment on your refusal to testify. You are presumed innocent unless proven guilty beyond a reasonable doubt. If at any point you plead guilty or no contest to these charges, and that plea is accepted, you would have waived your right to trial and waived the right to have this gone over with you. You have the right to be released on bond. Do you have any questions with regard to those rights?
No, sir.
Court's entered not guilty pleas as to all charges. Public defender will address bond for you.
Yes, Senator Jensen, on behalf of Mr. Whitsett, we stand mute to the charges and request a personal bond, please.
Thank you.
Stand mute.
Are you on probation or parole right now, sir?
Yes, I'm on here. I'm in the house. I'm on tether and everything. Yes, sir.
Okay. For which court?
I'm on parole.
Oh, you're on parole? Okay. All right.
Yes,
Oh, you've
sir.
been on parole now.
Puppy.
I'm almost off. I've been on there a year and like 7 months.
Okay. Is your tether, is that just tracking or you're in house arrest?
No, okay. Yeah, I'm in the house.
Okay. All righty. And
Look at his NWA poster, and he's stealing puppies. It was probably like a $5,000 dog. Let's get real here. It wasn't like a mutt. It was...
Are you drug testing for that?
Yes.
When's the last time you drug tested?
Last week, and my PO judge tested me Wednesday. I get just some community corrections and my PO.
Okay. All righty. Everything's coming back. No positive tests?
Oh, no. You can ask them. I ain't got no positive.
Gotcha. Okay. All righty. Okay. So I got a couple of cases here where there's alleged victims. So the court's going to order no contact with those individuals. Let me go back to those and so we can get those names on the record.
Yeah, sir. You said, I have one question. You said I stole money. They said I stole some money from Jeffrey Johnson.
Mr. Whitsett, I'd advise you not to speak on that. We can speak
Okay.
after the document is finished in further detail as to the litigation.
Yeah.
Okay.
Yeah, Jeffrey Jones is the name. The public defenders get police reports on all this stuff. They can go over with everything with you. They're going to get a lot more information than I've got here in the document files. Okay.
Okay.
All right. So on case 23S00050, you're not to have contact with Lauren McCrae. This means absolutely no contact, no indirect contact through family or friends, no text message, email, social network posting, telephone contact, or any contact of any sort. You understand that?
Yes. You said Laura who?
McCrae. All right. Case number 23S00051. No contact with James Johnson. Again, absolutely no contact, no indirect contact through family or friends, no text message, email, social network posting, telephone contact, or any contact of any sort. And case number 23S00208. No contact with Jeffrey Jones. Again, absolutely no contact, no indirect contact through family or friends, no text message, email, social network posting, telephone contact, or any contact of any sort. You're not to use or possess alcohol, illegal drugs, or marijuana, and you are to remain compliant with all terms of your parole. Any questions with regard to your bond conditions?
No, sir.
These conditions are placed in the law enforcement information network, meaning should you come into contact with the police, they will have access to that information. Should they witness or suspect a bond violation have occurred, you would be arrested for violating bond. You understand that?
Yes, sir.
All right. Your next court date will be May 8th at 9 a.m. via Zoom. Did you receive the text message for today's hearing?
Yes, sir.
All right. You'll keep on getting those text messages as long as your phone number stays the same. If you change phones, let us know.
Oh, yes, sir.
That's the same number the public defender is going to use to call you to talk to you about your case. So if you miss any calls from them, make sure you return their calls, okay?
Yes, sir.
Stay away.
All right, Mr. Whitsett, you're all set. Again, May 8th, 9 a.m. via...
My girl! She was in fuego today.
You understand that there's a recommendation for credit for time served, that that's only a recommendation, not something that this court may or may not follow that recommendation. Do you understand that?
Yes, ma'am.
Has anybody and you still, knowing all that, you still want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, counsel, if you can please order your client.
Sure. Mr. Jeslow, were you a passenger in a vehicle on April 5th in the city of Riverview?
Yes.
On that date and time, were you pulled over? Oh, I'm sorry, excuse me. Was it the city of Wyandotte?
It was mine. It was 4th Street in Eureka.
Very good, thank you. On that date and time, were you pulled over by a Wyandotte police officer?
At the end of the pursuit, yes.
Okay, very good. At the end of the pursuit, when the police officers came up to the car, did they see several knives, a machete, and a fencing sword in the vehicle?
Correct.
Were those?
If the pursuit, he fenced the cop. I can't. What's a fencing sword? Who carries the machete? Okay. The knife? Okay. A pew-pew? Okay. But a fencing sword? Dude, now I've heard it all. That was the highlight of that clip. We're going to jump. I just needed to hear that. Here we go. Travis County AM. If you haven't heard this judge in the morning, she starts me off. When I drive to work in the morning.
So my other young person over there,
It's her.
Brown,
She's my
still
Howard
with
Stern.
the doctor?
No, she's back.
She's back. Okay, now let's you and I talk. Deja, what's your problem?
What's up, Leather and Lashes? Hector.
I can't hear you.
Courtney.
Why you over there
See a
acting
lot
up?
of Credence and Mikey people.
Yeah, I mean, you know, HEB got cameras everywhere. Everywhere. HEB, Walmart, Target. Soon as you walk through the store, they watching you. What you doing? What you doing, mama?
I was with a friend and she left and I followed her. So it was just
You following the wrong crowd, madam. And your mama is pissed. You know she pissed.
Yes.
You driving her car, committing offenses.
It was the girl's car.
Okay, well, stop it. Don't follow her. She driving her mama car, committing
Really?
offenses.
It's a
I got
fool?
3 kids y'all age. Girl, you be on my knee so fast, and then I be daring the cop to arrest me. Cut it out. Ain't nobody got time for this. You have been charged with a Class B misdemeanor theft of property. The range of punishment on that type of offense in the state of Texas is up to 6 months in the county jail and a $2,000 fine. That bond has been set at $3,000. Do you have any questions regarding your charge or bond amount? Are you requesting a court-appointed attorney this morning to help you with this case?
I don't even know what that means.
Do you want me to have an attorney help you? Yes or no? All right, thank you.
Stop crying.
Now, over my best judgment, you have also been given a personal bond this morning. So you too will be processed for release, and you'll be released between 11 a.m. and 1 p.m. Do not come back up in here in this jail, because guess who you gonna see? Me. I'm not gonna be happy.
I love her.
Okay? Do you have any other questions for me? I didn't mean to make you cry, but y'all is acting up in this world right now. You have any other questions for me? All right, take care of yourself, madam. Next, we have Lillian Shapa.
If you watch her every morning, she's not this animated. Today, she definitely had her Wheaties today, because I don't know what was up or what's going on with her today. She's serious. She gives people lessons, but she was on it today.
Girl. What's going on with you? What is all of this? I mean, you fussing with the boyfriend, the ex-boyfriend mama? What we doing? Tell me what we doing, mama. Tell me. Why you fussing with her?
It's great. Welcome, Trisha Career.
Miss Shopper, it's not your house. If she asks you to leave, you gotta leave. You gotta leave, okay? Huh? What you telling me?
She not her hands on me.
You're a minor. She's an adult. That's all I'm gonna say. Now, I ain't saying nobody's right or wrong, but I need y'all to figure this out. Are you and this boy still together or not? Y'all broke up. So you fighting with a mama over the ex-boyfriend, and you ain't trying to get back with her. All I'm gonna say is I done got in trouble over many a man, okay? It's a whole lot of fish in them sea. Okay? So if you running behind this one getting arrested, I think I'm gonna need you to pick a new one, okay? It's a whole lot of them swimming around. Just pick somebody else. Because now you got 3 charges over foolishness. This is just foolishness. When I read this, I was like this, really? Really? This what we doing? Madam, you have been charged with 2 Class A misdemeanors. The range of punishment on those types of offenses in the state of Texas is up to 1 year in the county jail and a $4,000 fine. The first Class A misdemeanor has been...
I know some of you are asking, this is Travis County. This is AM hearings. So I'm East Coast, so Eastern Standard Time. That's like 5 a.m. for them. Sometimes 3-4 a.m. So she's live around here, around this area, around 6-7 a.m. She's on about 3-4 times a week, even on Saturdays sometimes. Yeah, these are only morning hearings. She's on AM very early.
Style as an evading arrest. That bond has been set at $5,000. The second Class A misdemeanor has been styled as an assault causing bodily injury. That bond has also been set at $5,000 plus a stay away from her residence. And lastly, madam, you have a Class B misdemeanor criminal trespass. The range of punishment on that type of offense in the state of Texas is up to 6 months in the county jail and a $2,000 fine. That bond was also set at $5,000.
Judge, is it criminal trespass or criminal mischief?
Oh, did I say trespass? It's a mischief. My apologies.
Perfect.
Do you have any questions, madam, regarding your charges or bond amounts?
No.
Are you requesting that I appoint you an attorney this morning to help you with your case? All right, now look, pretrial denied your personal bond request. And let me tell you why they denied it. Anytime you have a misdemeanor assault here in Travis County, they have to call the victim, and the victim has to agree that they are not in fear, do not feel threatened, and want you released from jail. They could not get in contact with her. She may have been deliberately not answering the phone. Who knows? But in any event, I'm going to go around them and go ahead and let you out of jail this morning. But madam, do not go following behind this boy back to this woman's house. Okay? Just let's find a new boyfriend. You pretty enough. You cute enough. You ain't got to be worrying about him. Especially if the mama and you are squabbing. You know what I'm trying to say?
She's great.
All right. So you two will be released within the next 4 to 6 hours, anywhere between 11 a.m. and 1 p.m. Do you have any other questions for me, Miss Chopper? All right. Take care of yourself. Thank you. All right. Next, we have Kiara Ray.
What's up, Rainan? Welcome.
Can you hear me, Miss Ray, from where you are? All right. Now, what's going on with you? You're a little older, so I expect you to act a little different. What's going on with you?
I don't know.
I mean, are you with this young man? Are you trying to get with this guy or something? Y'all arguing over this guy? What is it? Tell me.
She mad, like she just petty, like, cause we was friends at first. And then I was talking to him. I didn't even know she was trying to talk to him too. And then now I'm here.
But they was just talking. We can't talk to other people. What?
You don't gotta talk in the back seat with your clothes on.
I can't. She's the best.
Okay, I didn't know you was gonna say that on camera. Okay, listen. I'm gonna tell you the same thing I told Miss Chopper. It's a whole lot of fish in that sea, girl. You just gotta don't let these people put you in jail behind no foolishness.
She's lovely.
He talking to your friend, now you just go talk to his friend. That's the way you do that. You don't go to jail.
Rich.
Okay, now I hate to sound like your mama, but I got 3 kids y'all age. I got an 18, a 20, and a 22-year-old.
What's up, Steve?
How old are you, 21? You see, I got kids your age. I'm telling you the same thing I'm telling my daughters. Out here wilding out over these boys. Girl, like I said, what I just said, I'd have made plenty of bad decisions over boys. I have. You're not alone, but I need you to make different choices going into the future, okay? I have also granted you a personal bond, although they denied it, because again, to get a personal bond in Travis County on a misdemeanor assault, they must have contact with the alleged victim who says they're not in fear, do not feel threatened, and want you released from jail. Now, this person, because y'all are not related, right, so to speak, they couldn't get in contact with. But I'm gonna let you out, okay? Don't come out of jail, be on bond, and then have me on the news because you squabbling with this boy again.
Yes, ma'am.
All right. Are you requesting a court-appointed attorney this morning to help you with this case, madam?
Yes, ma'am.
All right. You have any other questions for me? Stay away from her and him, okay? Just let's get us a new guy. Go talk to his best friend. I done told you what to do to make him really sad. Go talk to his best friend. No, I didn't say that on camera.
Crazy today.
Take care of yourself, madam.
She was nuts.
All right. Next, we have Nakota Jones. Who's that?
Oh, it's
you?
raining memberships. Thank
Flaming
you,
hair, is that
Steven.
I like your hair. All right. You have a Class B misdemeanor driving while intoxicated. Can't drink and drive in Austin, madam. They're everywhere. They're on every corner. The range of punishment on that type of offense in the state of Texas is up to 6 months in the county jail and a $2,000 fine. That bond has been set at $3,500 plus an ignition interlock device. Do you have any questions for me, Ms. Jones, regarding your charge or bond amount?
No, ma'am, what is an interlock device?
Well, it's the thing you got to blow into before your car starts.
I can't afford that.
They'll make it county funded, so it's okay.
I can't.
Which means they'll waive a large portion of the fees.
Okay.
All right. Are you requesting a court-appointed attorney this morning to help you with this case? All right. Now, talk to me for a second. They denied your personal bond too, because they're saying you got a warrant from California. What's going on in California?
Been to California.
Santa Rosa? Where is it?
I haven't never been to Santa Rosa, ma'am.
That's not you?
I haven't never been.
You don't have a very common name, so they couldn't be getting
you.
It says Santa Rosa. Maybe it ain't California. I may be wrong. It says violation of a court order. Okay, I'm sorry. Santa Rosa PD, violation of a court order from November 25th of 2020. What happened with that? What'd you have in November of 2020?
I don't have nothing. I didn't do nothing in November 2020.
I mean, you had some from Washington something.
I was released on I got probation and I cleared my probation.
Where is this Washington? What state is this and what city?
Washington County.
What's that? Brenham? No, not Brenham.
Yeah,
What's
Brenham.
Brenham? Okay, I'm sorry. I'm sleepy. All right, so in Brenham, you resolve all your cases in Brenham?
Yes, ma'am.
Is the Santa Rosa PD in Brenham?
No.
Where do you know where that is?
No.
Okay. All right, I'm gonna let you out of jail because they can't resolve it either. And that's the only reason why they denied your personal bond. And if you did not have that, you would have been looking at your history, you would have been granted a personal bond because this is a first offense DWI and you're 37 years old. So
What up, one more thing?
That's the way we kind of weigh it.
What up,
So I'm gonna
Toby?
grant you personal bond, but please no drinking and driving. If you're gonna be driving, you gotta have an interlock in your car. And we'll go from there. Okay. What questions do you have for me?
So they're gonna let me out in how long?
4 to 6 hours. You'll be out anywhere between 11 a.m. and 1 p.m.
Okay.
You have any other questions for me? Don't come back. You don't want to see me, right? Take care of yourself, madam.
Thank you.
You're welcome. All right. And last but not least, are you Miss Crawford?
Yes.
All right now, madam. Really? POM in Bell County? How long you been fighting this? What's going on?
I love her.
Yeah, you should laugh. That's laughable.
When I first got charged, my public defender kept resetting and resetting and resetting and resetting my court date.
Who was the public defender? What's the name?
I don't remember his name. It's been so long ago.
How long ago?
It's been like 6 years.
On a POM matter. 6
Yes.
years.
Yes,
You
ma'am.
can't find your way back to Bell County to resolve this case so you don't keep getting arrested.
Yeah, I actually still live in Bell County right now.
But and so you ain't just got a ride or drove or took the bus or the light rail on over to the courthouse and got this resolved? You probably could have $200 and they would have been.
No, I was under the impression that I would have to basically turn myself in. And because
marijuana?
Yes, ma'am. I mean, I don't know. Like I said, it's been 6 years. And the only reason why I didn't go to court is because they kept me setting it for like a whole year. And, you know, I have to work, I have kids, I have, you know, I just.
Got kids, I got it. But girl, going to jail over this old case.
I know, the lady that booked me, she was like, really?
Yeah, really? I mean, it's costing me $200 just to talk to you for these 5 minutes. Do you understand that? I mean, you could have paid it and be done. So here's what I'm going to say. You got to just go and take care of it. Because all Bell County's going to keep doing is issuing warrants and picking you up. Issue another warrant, pick you up. And now that the governor has DPS down here in Austin, they picking up everybody.
Yes.
You've seen that in the news.
Pulled over is because he said he couldn't see the license plate on my boyfriend's car.
Yep, it's all traffic. Okay, so yeah, don't give him a reason to have you hemmed up in jail when you got kids and a job and you got a life.
Yes, ma'am.
So they set this at $6,000 cash assurity. I have removed the cash assurity condition. I've reduced the bond down to $2,500 to allow you to post bond out of Travis County and not have to wait the 10 days in jail for Bell County to pick you up. Will that help you?
Yes, ma'am.
I mean, I hate you got to spend your money again, but that's the best I can do is to reduce it, and then less than half. If you know who your court-appointed attorney is, you may not have to spend any money because what you're gonna do is you would get a phone call. Now that you've seen me, you call the court-appointed attorney and say, "Hey, I talked to the judge, Judge Jeffers. She says she give me a personal bond, but the only person that can get you a personal bond is an attorney, right? And if he's appointed, he will get paid by the court for bringing that bond to me and having me sign it so that you can get out, right? So if you know his name, call him. You're going to be given access to the phone now that you've seen me. Let them know, hey, the judge says she signed it if you brought it to her. Or if you know other attorneys here in Austin that you can do that. It's just that if they're not appointed, then they may want you to pay outright. That's all. So I'm just trying to give you a way to not have to pay.
If I do get a bail bondsman, how much would that be?
I mean, the going rate to get out of jail in Travis County right now is 5 to 10% of the bond amount. So on 2,500, that works out to be anywhere between $125 to $250 to any attorney or bondsman of your choice. I set it low enough so that you didn't have to spend a whole lot of money.
Yeah, I'm just gonna go ahead and get a bond, bail bond. I don't know who he is. She told me she would appoint me one, but she never told me a name or anything when I went to pre-trial.
Well, I'm just gonna tell you again, once you spend your money to get out this time, go sit in the courthouse until they give you some paper.
Yeah, I'm going to court. I'm gonna take care of this because I'm tired of, all of this. I don't want to do this no more.
Yeah, 6 years on marijuana.
Yeah.
Yeah. So you have any other questions for me, madam? All right. Take care of yourself. Okay. All right. Take care. All right. Officer Pettis, thank you for your.
All right. So we are going to go to. Oh, Laura!
And you are.
Thank you for the dono. Here's a little secret. I like to make myself laugh. You guys are just along for the ride. That's the key. You make yourself laugh. You stay young. People will laugh with you. You can't get any more real than making yourself laugh. So we went from Judge Sister Auntie to Judge Mom, and this is a mom moment for the books, people. I almost cried. But I got this because I saw the little kid, and we knew DeSanto, the little kid, was going to be great. But then she has a little back and forth with Dad, and it's just great. It's just classic DeSanto. What's up, everybody? Welcome. I see a lot of new people coming in. Madison joining again with the McNally. We are in McNally. We need our McNally fix. Oh my God, I can't. So let's rock and roll, people. I see a lot of new viewers, a lot of my old school. Just welcome the new guys, people. This is the greatest chat around. If you're in here for the first time or you're viewing, this won't be your last, I guarantee it. All right, let's go.
Alexis's father. Okay. I'm just going to disclose, I think we might be Facebook friends, but I don't think that but I haven't had any communication.
Facebook friends?
This matter. Is that correct? Correct.
What is she on social media for?
Any objection to this court continuing?
Don't be cheating on
Alexis,
me.
do you have any objection to this court continuing? No, Your Honor. Okay. So, I was chuckling because you're looking at your dad for your answers, but I know that you probably have your own answers, okay? All right. So you are here because you received a citation on March 17th of this year for prohibited conduct.
I love prohibited conduct.
Yeah.
They're the best.
And you spoke with the prosecuting attorney, and that was because there was tobacco use, possession by a minor, correct? Yes. And you and your father spoke with the prosecuting attorney, correct? Yeah. And the prosecuting attorney has indicated you're going to be pleading responsible. Is that your understanding? Yeah. Okay.
Exactly,
And
007.
So I'm going to have you raise your right hand. You solemnly swear or affirm the testimony about to give in this matter, the truth, the whole truth, and nothing but the truth. Okay.
I just knocked everything over. Oh,
As
God.
to the allegation of prohibited conduct, how do you plead? Responsible or not responsible? Responsible. And you understand you have the right to have a contested hearing in this matter, correct? And that by entering into a plea, you will not have that hearing. Do you understand that? And do you understand the possible penalty as a result of your plea? No. Yeah. And knowing all that, you still want to continue with your plea? No. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? No. All right, and so tell me, what is it that you did that you are responsible for prohibited conduct? Tell me what it is you did that you're in trouble for.
Tell me. She's such a mom. Tell me. DeSanto does it to me, guys. I'm sorry.
Okay. All right, the court does find your plea of knowing, voluntary, and factually accurate. And the court will accept your plea. And So you said it was your vape. How old are you? 13. So where'd you get the vape?
My older brother, I took
So you stole the vape? Did you know what was in it?
Denny's here.
And how'd you know it was in it? You just say, huh? If you don't know what I'm saying, right, I'm not somebody you're hanging out with, so huh is probably not appropriate. So, you know, if you'd like me to repeat the question, I can certainly do that.
13.
Okay. So how do you know what was in that vape? Okay, so you're assuming you know what's in there. Okay, because sometimes there's products or ingredients that are put in the vape that may not have already been in there when it was purchased. Do you understand that? So you stole a vape that didn't belong to you. You used it without knowing what was in it, and you're under 21. So if you were to test today, what would be detected in your system? When's the last time you used a vape? And where are you getting it from? Again? Is he just giving it to you, or do you keep on going in to take it? Why? It's not yours. No, you do know. Don't tell me you don't know. That's not a sufficient answer. You do know, because you make the conscious choice to go presumably into his room, look for it, and take it, and then use it. So why are you doing that? Well, you're here and not at school today, right?
Yeah.
Do you find being in court cool?
Yes. I do.
Do you think that you can stop vaping, or do you think you need help to stop vaping? You think so? So what kind of consequences did you get at home? Okay, so what did grounding entail? Okay, you have to get louder, closer to the microphone.
Not being able to hang out with friends.
So do your friends vape? And do you participate in any activities? And you don't think vaping impacts that ability? And yet you still use the vape?
Old popcorn
So that
lung.
tells me you can't stop on your own. Okay. And do you do anything to earn any money?
No.
I was going to say something really bad, but can't.
You offer to babysit for anybody, or to mow lawns, or anything like that? Help pull weeds, plant flowers, anything to earn some money? And to maybe take up some of your idle time if you don't have cheer right now? I'm sorry?
I don't do that.
You don't do what? Right, well, perhaps you should, so that you're the one paying the fine and not your dad. I'm also going to have you participate in a 15-week program. It's called Recover Detroit. And so there's no cost for that, but you're going to participate in that program so that hopefully that can help stop the vaping. Okay, so what I'm going to indicate is we're going to adjourn the sentence. We're going to set this for sentencing.
Sentencing? Can't you just give her a little probation, Judge? I don't agree with that. She needs sentencing. She's 13. Give her some probation. Make her go to those classes. Don't make her come back.
So we're going to set this for sentencing on August 1st. It'll be after the 15 weeks is completed.
Okay. I get it. Correct, Matt Perry. That's where I was going with my comment.
at 11:15. So you're not on probation at this point per se, but you have to go to the probation department so they can give you the information regarding the program. Part of it's online and part of it's in person.
Peach, you dirty dog, you.
And I'm also going to indicate as well that if you purchased any sort of, well, I don't know if you're aware, but there are nicotine testing kits.
Definitely leather and lashes.
I did not. I didn't even know she was doing this until within the last week or so. Sorry about that. No, I didn't really.
There is. So you
Welcome,
might want to
Casey.
look into that as well. But I believe that even through the 15-week Detroit Recover Detroit, that there's some testing as well. Would there be anything else in your system? You sure? Well, have you used marijuana?
Like yesterday.
Okay, and so where'd you get the marijuana from?
My brother.
How old's your brother? So he's not even legal to have vape. How much?
19.
Oh, okay, he's still not old enough to have the marijuana or the vape. So is your
Sashina,
brother just giving
welcome.
it to you?
No.
My mods will take care of you. Anything you need. Welcome.
I think that you're trying to protect your brother right now. You're just going in, you're taking his vape, you're taking his weed, and he's not noticing any of that.
Like when he's in the shower, he's going in his room.
Well, how do you know where he keeps it?
Just laying in his room.
Yep.
So what made you decide
Had the vape
to
talk, 00. Had a lot of talks.
try
Baby
weed?
time.
Right, well, you clearly need a new group of friends. You see the path you're going down right now? Do you like it?
No.
I don't think that you have enough
One more thing. Definitely.
of an ability to stop this path on your own. So you're going to be doing this Recover Detroit program. So we'll see you back on August 1st, 11:15. I certainly hope that during the summer, right, that you are doing something to earn some money or do some camps or activities, because the more idle time you have on your hands, the more trouble you're going to get in.
Gonna be hanging out under the bleachers.
Okay. All right. We'll see you back August 1st, 11:15. Please stop over at probation.
Thank you.
Thank you. All
George
right.
Mom
Have a good
moment.
day.
Bob Barnett on behalf of the township.
Oh. Mr. Corbin Tate, please state your name. Are you not close?
Replay if you missed it. Replay.
Bob Barnett on behalf of the township.
Bottom left.
Oh. Mr. Corbin Tate, please state your name. Are you not close?
Oh, he put a house coat on. A Gucci.
State your name,
Vuitton
please,
house
sir.
coat.
Corbin Tate.
Thank you, sir.
I just woke up. I apologize.
Is that a
Hey, why are
Louis?
you still suspended?
I can't.
You said what?
Why are you still suspended?
No, cause see what's going on is like I still ain't got my birth certificate in the mail. Like it's like I can't do nothing with it. And it's coming from another state, so you feel me? I'm just waiting. I'm trying to though. I ain't gonna lie. I'm trying to.
So have you called them to see if they actually sent it? Something is not right.
I did. I ain't gonna lie. I called them recently, but you feel me? I've been calling them.
This is more than a birth certificate. You haven't even taken care of the original suspensions.
What would that be?
You got suspensions out of 1482 District Court.
I was aware of that. Like, you had told me that.
Yeah, I'm pretty sure I did.
I was only aware of one, and that was a failure to display a license. That was the only ticket I'm aware of.
We are in so much trouble.
Reckless driving ticket.
I paid that.
Well, sir, you need to pay the reinstatement fee.
Reinstatement fee.
Actually, it's clearance fee, but yes, clearance fee. You need to pay the clearance fee. It's $45. That's probably what it is. If you're saying you paid it, you need to call to the 1482 District Court and pay that ticket.
So when I pay this $45, I was having to stop coming for this ticket though.
No, you got to get your license.
No.
I can't get it without my birth certificate. Like, you feel me? It's on the way. That's what I keep being told, but it's yet to appear in my face, so it's very difficult. But I can pay the ticket.
If your birth certificate showed up today, you're still suspended. You got to take care of the suspension and get the birth certificate. It's not one or the other.
I know, but to get my license, I got to retake the test and stuff, and I can't do that at the Secretary of State without my birth certificate. That's what they told me. I went up there 2 times.
Are you listening to the words that are coming out of my mouth?
Yeah, I'm listening.
You have to do both. You have to clear up the.
I went up there 2 times.
Are you listening to the words that are coming out of my mouth?
Yeah, I'm listening.
You have to do both. You have to clear up the suspension and have your birth certificate. So you got to do both.
All right, so how would I go about clearing it up? Like, I call and pay the ticket?
You got to call and pay the clearance fee, yes, so that you're no longer suspended. Doesn't matter if you retake a test. They're not going to reinstate your license when you're suspended. You have to clear up the suspension and take the test.
All right, so you said, who do I call? I promise you. You got my word. I'm going to go pay that today. I promise you.
1482 District Court, sir.
1482. All right.
All right. That's over at Judge Barr's court. Used to be Judge. We talked about this. It's Judge Barr's court. It used to be Judge Tabby's court.
Oh, yeah. So I go to that courtroom?
Oh, good grief.
Yes.
All right, I know what I said. Thank you. I promise you. You got my word. I'm gonna go pay that. I'm gonna try my best to do what I got to do about the get my license back.
Mr. Barnett.
I don't object to one more adjournment to allow him to try to do it. I'd rather have him have a license.
All right. This is the final adjournment, Mr. Tate.
All right.
All right. Are we here on May? No, we're at the P started.
Come on. When she turned the Zoom on. Oh my God.
June 6th, 2023 at 10 a.m. I'm writing final adjournment here. So make sure you get that done.
All right, I will.
Get a little Simpson up in here. This is a light-hearted Simpson moment. This is good. It's good. It's good to see him smiling again after the last couple of days. This poor guy has been going through hell and back. Today was good. He had some fun today. I captured it for you guys.
Under the supervision of...
Oh, I'm sorry. Under the supervision of Kim Thomas.
All right, very good. Where are you from, young man?
And we all know he always messes with the student attorneys. He messes with them. He's great. He's the GOAT.
Originally Pittsburgh, Pennsylvania, but I'm with the University of Michigan Law School.
Yeah, I know. But you're originally from Pittsburgh?
Yes, Your Honor.
All right. Are you a Steeler fan?
It's hard not to be when you live there, but I don't follow it too closely.
What does that mean? That was not enthusiastic. I'm thinking about denying this thing because I'll ask him again. You think?
Make him start from the beginning.
Make him start all over? No, I won't make him start all over. All right, but I'll ask you: are you a Steeler fan?
Absolutely, Your Honor.
Still was not enthusiastic, but that's okay. Because I was a Steeler fan probably 20 years before you were born. So I'm just saying, I'm a diehard Steeler fan. I'm also a Lions fan, but Steelers are my boys. All right, permission to practice is granted. You may go ahead. This is your petition. You may proceed.
Thank you, Your Honor. We're asking the court to use its discretion to set aside a non-serious misdemeanor from 1969. We've also received a background check from the state police and a response from the Attorney General. They found no issues with Ms. Crosby's eligibility. She doesn't have more than 3 felonies on her record. And in fact, the felonies she did have were expunged in the 22nd Circuit around 4 months ago. She has no criminal charges pending against her, and she has not been convicted of any criminal offense in the past 3 decades. So she easily passes the waiting period for the non-serious misdemeanor. As far as why the court should use its discretion to grant a set-aside in this matter, again, this is from 1969. It's a very old conviction, and as we laid out in our brief, there's really no question that Ms. Crosby's turned her life around in the decades since it happened. To begin with, she returned to school and got a master's degree in social work. She obtained employment with the county and started a long career of serving people who face mental health challenges. She's become a leader in her community. She was ordained as a minister in her church. She's served on numerous county boards and commissions, and even today, she's the president of the Ypsilanti Township Civil Service Commission. On top of all this, she's done decades of volunteer work, and even though she retired like 7 years ago, she's still at it. So all this barely scratches the surface, but we think it shows just how much she's gone towards rehabilitation, and we think that merits a set aside.
Good job.
The court would note that by agreement with the Washington County Prosecutor's Office, if they have no objection, they will not be appearing. So, Miss Crosby Robinson, what do you want to tell me?
I want to tell you thank you, first of all, for being able to have this opportunity to come before you and with this petition, and that it will really feel good if I can get this last thing removed from my record. I really do enjoy serving people who have challenges, considering I've gone through some challenges myself and overcame them, which is why I now work with survivors of human trafficking and provide trauma therapy groups and individual therapy, as well as an aftercare program that they just wrote a grant for that they want me to carry on with. And so at 17 years old, I sold a bottle of beer for $1 at what I thought was an after hour. Well, I didn't think it was after hours. It was supposed to be an after party. Turned out to be an after hours joint. Sheriff Harvey and his boys came in and raided, and there I was. Took us to the jail, and then this charge came out of that. And I think I have significantly changed my life since then. I make way better choices, and I try to help other women do that as well. And I really would just like to be able to have breathing room because, being in my 70s now, when I apply, if I come to the place where I have to apply for senior housing, I don't want this to be the thing that denies me entrance into a facility like that, because I promise you, I am not a threat to anybody.
Michael Bolton.
Yeah. I don't think so either. I also am curious because I think she might not have told me the truth because she said she was in her 70s. I don't think that's true.
SIMPSON.
All right.
So kind, Your Honor.
You dog.
So in dealing with human trafficking, do you deal with the 14B district court much?
No, I don't, but I would love to. And as a matter of fact, we have talked with Deputy Flores and Coordinator Derek Jackson about providing some training for officers in Washtenaw County, but we haven't heard back yet.
All right. Well,
Awesome.
Sounds like you do quite a bit. And I'll say, just based upon what I'm hearing, this this county is indeed blessed to have you. Working with some of those that, when you say they're facing challenges, that's probably an understatement. And it takes quite a bit of fortitude to be able to deal with a lot of that. So, based upon the allocution of counsel and Ms. Crosby Robinson, the court would find that the circumstances, well, that an opportunity has been given for the Attorney General prosecuting official to contest this application. Court does believe that the circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of this application do indeed warrant setting aside the convictions, and also does believe, certainly based upon what she does for people now, that it is consistent with the public welfare. Therefore, the defendant's conviction is hereby ordered set aside. Ma'am, I have signed the order.
Thank you so much, sir. Have a blessed day.
Thank you. All right.
That was awesome.
Thank you, Your Honor.
Thank you.
That was great. That was great. That was a feel good and a half. All right, here we go. Let's get into.
Does call the cases of the people of the state of Michigan versus Sabrina.
Okay, here
Consider
we go.
asking them. Understand that the cases we have.
Okay, so I love kids. I work with kids, have kids, all about it. But dude, really? You're going to see what I mean after a couple minutes. Like, my crazy life and I were like, enough in the Discord today. Like, enough. You could see right now. And look at Drew Carey over there, the bottom left. This is the first TPO. It is unbelievably funny. Here we go. Enjoy.
That get set for hearings usually get set for hearings because the parties don't agree about the facts. Asking questions about those disagreements, you need to decide whether that's a helpful question or not a helpful question. The way that this will essentially follow is the petitioner will testify, make statements. The petitioner or respondent will have the opportunity to suggest those questions. I'll ask the ones I think are helpful and appropriate. And then from there, if the respondent wishes to make statements or present evidence, then they will do so. In a family violence case, the standard of proof, again, is more likely than not, but the question that we are tasked with answering, there are a few. Whether we have jurisdiction over the case, whether the respondent has been predominant aggressor in one or more acts of family violence, and whether the imposition of this order will help prevent certain such acts from reoccurring in the future. And so with those questions at the heart of the matter, we're going to begin shortly. So I've sent a prompt to the petitioner, Mr. Jason Pike. I'm going to ask you to unmute and then raise your right hand. Do you swear that any statements you make to the court will be the truth under penalty of perjury?
These guys are so
awkward. Thank you. You can put your hand down. The respondent is your brother, correct?
Yes.
And he lives in DeKalb County to the best of your knowledge?
Yes, sir.
All right. And so in reviewing your petition,
we're here
there
for
are a few different allegations here that have happened over the during 2023. So let's start. Let's see. And so you said that in February there was eviction paperwork to have you moved from your home. You live in Cedartown, is that correct?
Yes, sir.
And who owns the home in which you reside?
Yes, sir, it is.
No.
It's owned by my mother. Apparently, my brother has somehow gotten power of attorney over here. I somewhat question the power of attorney because my mother is housebound. She really can't leave the house. So I don't know how she would sign paperwork and have it notarized inside the house unless they had paid a notary to come to the house.
Okay, now is she residing with your brother right now?
Yes, and that's one of the issues there is that apparently, I mean, when I applied for the ex parte, I had my mother included on it, and Jonathan has not left the house in DeKalb. that he's still there and technically breaking the order, the ex parte.
Yeah, that was not appropriate that you included her. I can just tell you that. She is an adult over whom you don't have power of attorney. And so you're not in a position to make that request, even though she is your mother. That's true of any adult for any other adult. Georgia requires them to seek their own orders. Adults can file on behalf of minors, but
I understand.
so that's probably how that got stripped out of there. Now, what's the status of the eviction case? Still pending, or has it been handled?
Correct. Amazon.
So yes, we had a hearing a couple of weeks ago. Jonathan really upset at the hearing because he was trying to have me evicted that day. He did not give proper notice to the courts.
I just need to know what the status of the case is. Is it open or is it closed?
Basically, they gave a 60-day notice for me to be removed from the premise on May 20th.
Okay.
And this was all action initiated by Jonathan.
Good observation, Leather and
All right, and you discuss an incident in, you said March 11th, that he tried to enter your home?
Yes, sir. We have Ring doorbell cams. Jonathan tried to enter the property, even though we had it posted no trespassing, and he without notice entered the property without giving notice to my wife that he was trying that. He also then
Now, what time of day was this, roughly?
This was about 9 or 10 o'clock at night.
Okay.
And then a few days later, he actually then had Polk County police escort him onto the property and tried to have my wife evicted there without any eviction paperwork at that time. The police refused to comply, evict my wife there at the time.
And she's not directly a party to this action, but so I won't use her full name, but is that her name that starts with the B?
Yes, Bryson.
Okay. If you're going to.
I know.
We do stream to YouTube, and so I try to be a little bit cautious about people's personal information in case whoever I'm speaking with,
I understand.
Thanks,
more
Judge
private
Dude.
person, but
Don't worry.
I'm
We'll
glad
blast
to
it
hear
out
you
for
feel
you.
comfortable with that. So,
so
he came to the property at 9 or 10 o'clock at night, and what are you saying he tried to actually do?
He's vaping. He just
basically tried to enter the property with the key that they have for the property. We have secondary locks on the door, and so he was not able to enter. And then a couple of days later, he was escorted onto the property by the Polk County Police Department. And at that point, he tried to have my wife forcefully evicted from the property, saying that she didn't have a valid lease. The Polk County Police Department did not comply, said that this was something to be dealt with in the courts.
Okay, so were you there when he tried to enter the property?
No, sir. I was incarcerated at the time in the DeKalb County Jail for a false police report that he filed. I spent 63 days. That was another allegation in this, is that basically when I moved out of the property back in November, Jonathan filed a police report saying that the stuff that my belongings there were actually his, and that I stole them. And this goes back to the original ex parte that I tried to get, that he is trying to get my parole violated. And so this was that the parole officer investigated. I gave him the information, I gave him the evidence of the recordings of what Mr. Pike, what Jonathan said, and parole deemed the case not worthy of them. On March 16th, I think it was Judge Jason, we had a preliminary hearing, and she agreed with us to the degree that she gave me a UDR at the time. So she doesn't seem to in my opinion, she doesn't seem to think there was any merit to the case as well.
Okay, and so a condition of that release was that you have no contact with your brother, correct?
Yes, no contact with him or my mother.
Okay, and so,
sir?
And so it was about a week after your release that you said he was at the house.
Week
evening,
before,
correct?
The week before my release is when he came to the house.
So that was the first half of March?
Yeah, so I was released on March 17th. The incident where he came to the house was on March 11th or 12th. And this was relayed to me by my wife. She has actually fled residence because they also, I don't know if Jonathan came and cut the grass or if he had somebody else come and cut the grass at the property, and that they were beating on the walls like they were trying to break the window or enter the property through one of the windows.
And when
so
was
that's
this?
when my wife actually fled the property, and has gone into hiding. I don't even know where she's at.
So when was that?
That happened on, I want to say the 13th or the 14th. I would have to look.
Of what?
March.
So prior to your release from custody?
Yes.
Okay.
And this has all been related. Go ahead.
Okay. So you were in custody from January until mid-March, right?
Yeah. Yes, sir.
Okay. And I don't see anything in your petition that has happened since your release in March. Is that correct?
I mean, since the petition in March was the eviction that he has put on to us. That I think is just basically legal abuse, that he started these proceedings while I was incarcerated with I guess the hope that I would not be released in time to actually fight the eviction properly.
So your solution to believing that one legal process was a fiction or a fraud was to file another legal action so that there could be multiple different things going on in different places at one time.
Oh, sir, I mean, I don't want to be here. I don't want to be taught. I mean, I'm not saying this that I have anything against you personally, but it's like this, he will not leave us alone. All we want to be is left alone because of his actions. Like right now, I'm saying instead of having custody of my girls back, we were supposed to get our two daughters are in defects custody, and we were supposed to have gotten them back in March. But because of his action of filing this police report and having me incarcerated, that has been delayed, put off. I mean, it's just like he is trying to do everything he can, legally, illegally, to whatever degree, to just make our lives a living hell. I mean, I don't know what else to say. I mean, he's tried to kill me. He's assaulted me. I mean, what else? I don't know what else to say. I don't know what else to do. I mean, when somebody drains the brake fluid out of your truck, to me that's you're trying to kill somebody. When you tip a dryer on top of somebody, to me that's you're trying to kill somebody. I mean that's and this is stuff that he has.
Here's where I'm going to jump in. These orders exist to address and treat ongoing threats to the safety of the people that are involved. Now, the record in this case that you have established through your testimony, because this is your case, not your wife's case. You don't know where she is what you told me.
Yes, I do not know where she is right now.
For the last 90 plus days, have had no contact with your brother because you spent about 60 of those 90 to 100 days in the DeKalb County Jail, and your petition does not allege a single incidence of contact that has happened in the month or a little bit over a month since you have been released. So what we have is a record that establishes
I'm alleging contact with the eviction.
That is no. I'm just going to say no. That is not. This order requires that acts of family violence be committed against you not
Well,
that he
we had a
filed.
valid lease. We had a valid lease signed for 5 years, and his whole
And the place that you handle
reasons
that
they-
is in court at the eviction case. You don't do this. You don't initiate another court proceeding and then try to reframe that as harassment. There are remedies in the legal system.
And then also,
Please stop
and
interrupting
there's something
me.
else. Okay. Well,
There are, and even then, the words out of your mouth were okay, well, and then you continue talking. There are things, and even then, the words out of your mouth were okay, well, and then you continue talking. There are things like punitive damages, awards for attorney's fees, and things of the like that can be awarded to you if fraudulent legal action is taken against you. And what I will tell you is that in this case, the record that has been established is that your brother has had no contact of any kind, not just violent contact, not acts of violence, or certainly not family violence. He has had no contact with you of any kind since your arrest in January. Now, when this case was last before the court, and I'm going to use the term this case, even though that's not exactly accurate, there was a different case number. But the last time this case was before the court, a large portion of our time was spent litigating things that happened before the dismissal of the case before it. And so what we look at in addressing ongoing emergencies, what you are asking the court to do is restrict the freedom of another person. And Georgia law, which is very deferential to the concept of freedom, that's true in how Georgia handles any number of things. It has a civil libertarian streak in the law that very few states do. We are I think we are the only state in the country that has an exclusively criminal traffic code. And the reason for that is because that guarantees you the right to a jury trial, even for running a red light. And we will take 6 people and make them take a day off work and decide whether or not you ran a red light, if that's what you want to have happen. But the way that that carries over into protective orders is that these orders exist to address short-term immediate emergencies. And the record in this case and the record in the last case establishes that there has been no act of family violence within the last 5 months because there's been no in-person contact between the parties in approximately that time. And the other portion of this is that to issue a protective order, this court is required to make a finding of fact that this order, this one, will reduce the likelihood of acts of family violence occurring in the future. The petitioner in this case, that's you, Mr. Jason Pike, is already subject to a special conditions bond that you should have no contact with him. And so having this go back the other way to say that I should do a second order that then reinforces he should have no contact with you, and I'm bobbing my head based on where the two of you are on my screen because each of you is on one side of me. It may be different on your screen, but that is neither appropriate nor legally effective. It creates confusion and hardship and difficulty. And so what I will say is the petition in this case on its face fails to establish acts upon which a protective order can be granted. And the testimony, even taken as true, regarding issues of the eviction and issues that took place at the house when the petitioner was incarcerated, are not acts for which a temporary protective order can be granted. Now, if your wife felt she was being harassed or threatened or harmed by this man, and she chose to file a protective order, then she could have a hearing about the things that she experienced because she's an adult and that's her choice. And the court would hear that and the court would rule on that. But I will tell you that the things you're describing, filing an eviction, for example, it's not acts of family violence or stalking. These are things that frivolous legal actions have penalties all their own. And those penalties are levied in the context and within the confines of the case that is the fraudulent legal action or the frivolous legal action. But when the solution is to start a new one with a new case number and start more problems, we run into any number of difficulties.
So,
And
sir,
so while the difficulties you've had with your brother go back years, and I am sympathetic to what you've been through in that regard.
So when he text messages me, saying that he's going to kill me and my wife, on January 10th, that's not contact. I mean, that's that it made to the point where that the solicitor's office said that they were going to apply for a bond revocation, in the case against him because of his contact with us on January 10th, saying that he was going to, hurt my wife, hurt me, and while we still had a protective order active, and that's no contact. I mean, by your own definition, that was contact. That was violent contact.
So
I mean, this was, and I mean, right now we have warrants. I put a warrant application in for 2 counts of aggravated stalking because of this. That was the whole reason I even found out that I had a warrant for my arrest, is when I put the police report in for the aggravated stalking, that they ran my name and said, "Hey, you have a warrant for your arrest."
Oh, I wish the brother wasn't muted.
I mean, I submitted this to the solicitor's office. They said they're going to ask for a bond revocation hearing in the case against him.
You're saying that this incident, that this text message was sent to you in January, which was almost 100 days ago.
Yes, and the next day when I filed the police report was when I was arrested on January 11th.
And so,
and if I could have filed the TPO back in January, I would have. But I was incarcerated from January 11th until March 17th, and within 4 days of me being released, I filed for this ex parte. I mean, literally the first chance I could get to file this, I did. First chance I could to file the aggravated, apply for the warrants, application for the warrants for the, for the aggravated stalking, I did. I mean, I don't know how long it takes for the warrant applications to go through, but I mean, I've started the process.
And
I mean,
and so when are you alleging that this message was sent to you on the 10th?
So it was sent to my wife's phone. I saw them come through. They dealt with both me and my wife. And that basically he was harassing her to basically harass me, and this all happened within.
Yeah, that looks like a supervised visit, guys. Because he said leather and lashes, that was a great observation. Because that looks like a room with the seagulls in the room and all that stuff. And look at the vents. He's not at his house. He's definitely at a supervised visit for family services.
10 minutes of us getting off the Zoom call back in January.
And so you were not subject to so the court order that you're referencing that you say he violated would be the court order from his bond?
No, well, the ex parte plus the court order from the bond, because it was violent contact.
So the answer is you're alleging that he violated his bond.
Violated the bond, violated the ex parte at the time.
Well, he didn't violate the ex parte because you had already gone to court and lost.
Well, then does the ex parte then go out of effect as soon as you say, it's dismissed, or does it go out of effect when you sign it and file the paperwork? I mean, within 10 minutes of the hearing being over is when the text messages started coming through, because he felt like he could then start, texting and harassing us.
Here's the problem. Where's your wife?
Like I said, she's in hiding because of what he has done.
Okay. So let me click back over to this case. All right. Did you submit any exhibits along with this case?
I submitted to the Victims Advocate service from the solicitor's office. I submitted the text messages, and she said that they would get those to you guys. I can I've got copies of the text messages now. I've got copies of it from the police report. I mean, I've done everything I think I can do, like beyond coming, to the actual court and dropping the evidence off directly, to get it to you guys.
Right.
If I need to do it again,
this
I will do it again.
This is an opportunity for, we'll say, clearing the air, but also sort of level setting about some of these things. First, the message was sent to your wife.
Yes, it was sent to her phone that's in my name, so that you could say the phone was, mine as well, because I was the one paying the bill.
Mr. Pike, these things get tiring. Like 5 minutes ago, it was, well, is it when you say it's dismissed or when you sign the dismissal? And these are the types of parsings and behaviors that they, I guess what I would say is, in some ways, they kind of tell on you that you want to be picky about things when it suits you or when it's helpful, but
I'm not trying to be picky on any of it, sir.
Here's the thing. In January, when we came before the court, there were 2 months without contact. You're saying that these messages were sent in the wake of
the hearing
this happening to your wife. You're saying that things happened to your wife. She's not here. And to the extent that she was the one that received the messages and that they went to her phone, regardless of whose name is on the bill, one of the requirements, I can't sit here and a terroristic threat is a unique allegation. Because in most circumstances under Georgia law, the testimony of a single witness is sufficient to establish the fact if the court deems or if the jury deems that testimony to be credible and truthful. And one exception to that, and there are a small handful of exceptions, but it is a small list, is a terroristic threat. And so questions that I would want to ask in a circumstance like that are, to your wife, where was she when she received it? What time was it? What date was it? What did you do next? To say, oh, well, I showed it to Jason or whatever.
January 10th of 2023. It was about approximately 12:13.
So as I said, these are questions I have for her, not questions I have for you, because you weren't the one that received the message.
I was right there next to her when she got the messages. I witnessed the messages directly. I've got copies of the messages that were sent. I mean, I've submitted them to, the solicitor's office. I've submitted them, to the resource center.
And in the time, and the 21 plus 28 is 49, 31 is 80. So in the 98 days since that message is received, you have not laid eyes on your brother unless it's on Zoom. Is that correct?
We met in the court for the eviction hearing, but I have not laid eyes on him.
You haven't laid eyes on him outside of a court proceeding, virtually or in person, in the last 98 days. Is that correct?
No, I have not.
Okay. And so what I will say is this. My finding based on the evidence presented, based in part, there is a no contact order against you. There is a special conditions bond of no violent contact against him. Introducing additional court proceedings into these equations needlessly complicates what we have. You indicated that the solicitor is pursuing legal action. You have the ability to respond and fight for your rights in your eviction case. You also have a special conditions bond, whether you believe the case is just or unjust, that you need to abide by. Now, I don't know if your wife has ever lived with him or not, such that, like, in the same residence, I don't mean like as a couple, but like if they've ever lived together such that they have a family violence relationship. They might not. But the situation here where there has been no contact for this extended length of time is not what an emergency protective order aims to address. And so the remedies you believe you're entitled to because you believe you're wrongfully evicted, you should absolutely ask for in the context of the eviction case. The help that you think you need in regards to the criminal charges against your brother, continue to coordinate with the solicitor to pursue that assistance. It is a but what we are dealing with here, the focus in these types of hearings is on recency. And in that context, there is no recent because we are at 98 days of no contact between him and you. And when these cases are considered by the court, they are, as a practical matter, considered between the adult that filed them and the adult that's on the receiving end of it.
Well, I mean, I take legal abuse as context, sir, but that's my opinion. I mean, we're all
well, context doesn't change facts, and this is a situation where the court doesn't have discretion to act on what it believes is right. We have to have predicate things that we believe have taken place to a sufficient level of certainty before we are even allowed to consider intervention. And so you and your wife can consider where you were when you received your messages. You can consider legal action from a criminal aspect in that jurisdiction, because that's the place that should have it from the criminal side. And then if the solicitor chooses to do something on your behalf in their case, that will be heard by the judges to whom that case is assigned. But in the context of this case, where there has been no contact between the parties for 97 days, this protective order is going to be denied and this case will be closed. The legal matters that are pending between the parties will continue to pend in the place that they are. And what I will say is this, in case it wasn't already clear, it sounds like neither of you wants to have contact with the other. And if either of you were to initiate contact with the other, especially of a harassing, violent, or threatening nature, you could be jeopardizing a bond, or you could be creating a cause for new criminal charges to exist. Mr. Pike, just to keep in mind with respect to the terroristic threat, that additional witness or that firsthand source, and I understand that you're saying your wife conveyed to you these messages upon receipt, but you know, if there is, you know, she would have a part to play in this, because the things you were told or shown, he has a right to question that witness, is essentially what that comes down to. And so and I think that's a big part of the reason that law was set up the way that it was, to have a different fail-safe in it because of the nature of the allegation and the charge, compared to some of the other things that one might experience in a criminal law context. And so that is going to be my ruling based on both the face of the petition and the evidence presented in today's hearing. The parties will be placed in the waiting room and will be free to log off thereafter, with instructions to continue with any other court proceedings as required by those courts.
The brother didn't say 2 words. Look, he didn't say 2 words. Look how it ended. All right, so this is what we're gonna do. I got a good one from Webster today, and then I'm gonna give you the surprise. Here we go. It's just a good court case. The surprise, guys. It's a really good one that popped into my lap, like when I was finishing up work, that I had to like stay an extra hour and a half at work just to record. Here we go.
Court of Greenwood County, Kansas. The state appears by and through County Attorney Jill Gillette. The defendant, James Robert Shingle, appears in person, in custody, and pro se. Mr. Shingle, you are charged with 1 count of criminal deprivation of property. The state is alleging that on or about the 16th day of April, 2023, in Greenwood County, Kansas, you did obtain or exert unauthorized control over property with the intent to temporarily deprive the owner of the use thereof without the owner's consent, but again, not with the intent to permanently deprive the owner of the possession, use, or benefit of property, to wit, a 1990 Toyota. This, as charged, is a Class A non-person misdemeanor. That means that if you were to be convicted, you could be looking at up to a year in the Greenwood County Jail where you are now, and you could be ordered to pay a fine up to $2,500, as well as costs, fees, and restitution for any damage to the Toyota vehicle. Do you have any questions at this point, sir, about what you're accused of or the possible penalties I've gone over? Okay, I didn't hear you, sir. Could you push that button again?
No.
Now, you do have the right to an attorney. You can hire any attorney of your choice. If you cannot afford to hire an attorney, you can apply and see if you qualify for a court-appointed attorney. So do you intend to have an attorney represent you on these charges? Or this charge, I should say. And I can't hear you if you're speaking. Is there anyone that can help you with that microphone? Because I just can't hear you. I don't know if you're not pushing the button or if you're too far or too close. My question to you, Mr. Shinkle, is do you intend to hire an attorney, apply for court appointed, or represent yourself on this misdemeanor charge?
I don't have any money.
But my question was, do you intend to have an attorney? Do you want to hire an attorney, apply for court appointed, or represent yourself?
Yeah, I just waive everything and whatever. I mean, I'll serve a year right here in county. Sounds good.
All right, so you said you don't have any money. That means you probably can't afford an attorney. Do you want to apply for a court-appointed attorney to represent you? Or do you wish to waive your right and represent yourself as you indicated?
No, I guess court appointed.
All right, what's your final answer? Court
I
appointed?
don't know.
All right. Well, it's your call to make, Mr. Shinkle. I can only tell you what your options are, and then you pick which one you want to proceed with. I've heard two so far. I've heard you say you're going to waive and represent yourself. I've heard you say you're going to apply for a court appointed. Either is fine. I just need to know which one you're going to stick with.
Court appointed.
Very well. Let's ask you some questions and see if you qualify. Are you employed?
No.
Okay. How long have you been without a job?
Only about a month.
What did you do up until a month ago?
I was in prison.
Okay. And how long had you been there?
90 days.
So blunt.
So for about 120 days, it sounds like you've been out of work. Do you have any kind of training or skills for a job?
I mean, I can work anywhere.
All right. And you don't have any money at all?
No.
Any property that is available to you to sell or anything like that? Okay, you need to speak out loud.
I mean, yeah, I'm hooked up with a family that's got some land, but I mean, they're still alive, so it's not, I don't know if I'm in.
Yours? All right.
Huh?
So you don't have any that you have title to right now? Your name's not on anything?
No.
Okay. I will appoint an attorney to represent you. That attorney's name will be Shannon Cooper. And I believe the officers there can give you her contact information. And we will give you a court date. Missy, when is the court date?
It will be May 30th
210.
at 3:30.
Thank you, Daylight.
So contact Ms. Cooper's office, give them your contact information, and try to have contact with them before the hearing, May 30th at 3:30, so Ms. Cooper can represent you. And then there is the issue of bond. Where do you live when you're not in prison or jail?
Wherever the wind takes me.
Okay, you didn't have to, you didn't get a conditional release to a certain residence?
No.
You're
They
not
wanted me
on-
to go to Emporia Mission, but I had to go back to my parents' place in Fall River to get my identification.
Will you be living with your parents in Fall River if you get released?
If they can put me back to Emporia to the mission, I'm trying to get enrolled into college so I can go become a writer.
Is the mission like a rescue mission, a homeless shelter?
Thank you, Tupac.
I think that's what it is. I don't know. I couldn't tell you.
But you have spent some nights there?
Do what?
You did spend some nights there at this mission or not?
I don't know. Wherever, if I'll call everybody I know and see if they'll let me come stay with them until I can get my stuff back together.
Okay, Miss Gillette, what have you to say about bonds?
Judge, I think the bond needs to remain where it is. He doesn't have an address or home. We don't know who's going to be tracking him or keeping track of him. You know, frankly, he needs a bondsman to know where he's at to be reporting through and keeping track of him. He's had convictions in Elk and Harvey County, one for aggravated battery, great bodily harm, and one for distribution, possession with intent to distribute heroin or meth. Those were both in 2017. And is currently on Lyon County in-state post-release parole since March 21st at 2023. He had last had a parole violation January 5th of 23. So he's on parole, and I don't know if they're going to issue a parole warrant based on this case or not yet.
Is the deputy there with you at the jail, sir? Mr. Schinkel?
Yeah.
What is your bond currently set?
I have no idea.
Is the deputy able to tell us? Is it 2,500, 5,000?
I wish I was like this guy. The care in the world. Thank you, Ran. 7,000.
Deputy, can you hear me?
He's in the other room. Hey, is he in there?
The jail sheet says 10,000.
10,000.
No, they're wanting to talk to him.
All right. Now, if the jail sheet says 10,000, that's probably what it's set at. I was just checking what the bond is set at, deputy. Is it 10,000?
Oh, let me go grab the paper, Judge. I'll be right back.
Okay.
This guy rules.
And that's what you're recommending, Ms. Gillette, is it stay at 10,000 cash or surety?
Yeah.
Okay.
If anything smaller, I wouldn't want to go below 5,000 cash or surety, just so we know where he's at and somebody like a bondsman would track him.
Okay. Have you lived ever outside the state of Kansas, Mr. Schinkel?
Yeah. My residence right now, if he'd take me back, that's somewhere I could go.
And where's that?
Fall River.
Okay, that's your dad?
It's family, yeah.
Okay. Deputy, what's his bond at? Is it 10,000?
They don't give me a copy of the warrants back anymore with the bonds on them. They don't think the county attorney needs a copy of her warrant back.
No, they haven't filed it in the court file yet
I
either.
want to know what the bond is.
They'll probably do it after he signs it. Deputy, what do you have the bond set? I can't hear you, sir. We're having problems with that microphone today.
Were you talking to me, ma'am?
Yes, sir. What is the bond?
10,000 is what I'm showing, yes.
Okay, and do you have any holds from DOC or anybody on him?
Not that it says on the jail sheet, no.
Okay. How was the vehicle damaged? Was it returned, Miss Gillette?
He had driven back after taking it. He tried to take it several other times before, and he had taken it this time without permission. While officers were there, he actually drove into the residence with it and came back to the residence of his father.
So was this his father's car that he allegedly took without permission?
Yes.
And his father reported it stolen, apparently?
Yes.
Okay. But he didn't damage the car. I'm going to leave your bond right now, Mr. Schinkel, at 10,000. But if you contact your attorney and she has any information to persuade me to reduce that, I would consider it. And I imagine the officers will help you try to call Miss Cooper. Okay. Any questions, sir?
I love the Eddie Furlong
Speedy
reference.
trial. Can we go ahead and put in for the, whatever it is for the speedy trial? Or just take care of
Well, I
whatever
can
it is
set it for a
today?
bench trial, but or for a jury trial. The jury trial would be in June.
I mean, I'm not wanting to sit around for too long. If you can go ahead and do it today, you said it could.
Well, I can't try your
maximum of a
case
year.
today, and I can't.
Huh?
I can't try your case today. The state wouldn't have their witnesses. Miss Cooper couldn't be prepared for your case today. Missy, do you have anything soon, since he is going to be probably sitting in jail?
That was nice of Webster to do
When's
that.
our
I'm
next-
sorry, Judge. What was that? I was on the phone.
When's our next docket that Miss Cooper will be here, in case we could move this up so he doesn't, since he's probably going to be sitting in jail?
Well, she'll be here at 3:30, but she doesn't have discovery or anything.
Right.
We could do April 25th, next Tuesday.
All right, I'll move that up till next week, April 25th at 3:30. And then you can talk to Miss Cooper and see how you want to proceed from there. Any other questions, sir?
No.
No? All right. Okay, then you may go at this time. We'll be in recess on Schinkel.
Ann, what up, Ann?
And we'll take up Monica Burton on the record in 2023 CR 64, State of Kansas
Okay,
versus
here
Monica
we
Lynn
go,
Burton.
people.
Please announce appearances.
Here we go, people. Let's do it. So now I'll give you, this just popped up in my feed, and I saw the visual, and I said, let me sit. I recorded. I've had any complaints. I don't know. I don't know about the ads. I'm not doing anything different. So I'll see what's going on. If you have the premium, you don't get ads. I never get ads. So I don't know. I'll see what's going on. Here we go. Okay, here we go, baby.
We'll go on the record in the matters 22 CM 122, 22.
Burnett County, baby. Here we go. Let's do it to it. Who is the inmate she is talking to? What is going on? You will find out.
CM 211, 22 CM 212, State of Wisconsin versus Richard Von Domelin. The state appears through District Attorney James Renicky in person. Mr. Von Domelin appears in person with his counsel, Michelle Erdman. We have Victims' Rights Compliance, Mr. Jason Klinkhammer, victim of this case, is appearing by video conferencing in custody at Bayfield County Jail on other unrelated matters. We're set here today in the matter for a status, but it's been converted to a plea and sentencing. I've received a plea questionnaire waiver of rights. The agreement is that he would plead to a disorderly conduct with.
You know what may happen? I usually do I usually schedule my lives through my Streamlabs. Today I did it through YouTube because I wasn't home, so I scheduled it while I was getting home. I was driving baby time to practice. So maybe that was it, because that's the only thing I've done different. I'll check it out, guys. If you get another one, let me know.
Domestic abuse enhancer, as well as 2 misdemeanor bail jumpings. Is that correct, Ms. Erdman?
Yes, Your Honor, that's accurate. It's free to argue.
Free to argue.
And everything else is dismissed and read in.
All right, thank you. Mr. Von Domlin, I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes, ma'am.
Did your attorney go over this document with you?
Yes.
Did she read it to you word for word?
So the guy who, the defendant is the one in the green shirt, the light green shirt, bottom right. And you'll find out who the rest are.
Yes.
And do you understand everything?
Yes.
Is that your signature on the second page?
Yes, ma'am.
And that's the agreement that you reached?
Yes, ma'am.
You're 65 years old. You can read, write, you understand the English language?
Yes.
You suffer from a mental illness or disorder, and what is that?
I have severe depression and anxiety.
And do you take medications for that?
You bet.
And did you take them as prescribed? Do you take them as prescribed?
Yes.
Okay. And so you've taken them as the doctor told you here today or yesterday?
Yeah.
And do they interfere with your ability to comprehend or to understand what's going on?
No.
And are you in a position where you feel that you are in as much of a calm state as you can be?
Yes.
And you understand everything?
Yes.
Okay. Other than that, no medications or alcohol?
No.
Because you're being charged with crimes, you're entitled to constitutional rights, and each of these rights is listed on this document. And your attorney read those rights to you, is that correct?
Yes.
Do you understand those rights completely?
Yes, I do.
And do you need me to go over those rights in more detail?
No.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
And do you understand that this is what's called a free to argue, meaning that the state can argue anything, as well as your attorney, from anywhere from a fine all the way up to the maximum possible penalties? Do you understand that?
Yes, ma'am.
And do you understand that here the state would have to prove with the disorderly conduct with the domestic abuse enhancer on or around June 30th, 2022 in Burnett County, Wisconsin, while in a private place you engaged in indecent, boisterous, abusive, profane, unreasonably loud, and otherwise disorderly conduct, which did tend to provoke a disturbance. Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you face a $1,000 fine, 90 days of incarceration, or both?
Yes, ma'am.
Do you also understand it contains the domestic abuse enhancer? That means that upon conviction, there will be an additional $100 DNA or $100 surcharge, as well as a federal prohibition to being able to use or possess a firearm for life.
Yes.
And you understand with regards to the misdemeanor bail jumps that in 22 CM 211, the state would have to prove on or around November 29th, 2022 for count 5 that you were charged with a misdemeanor in Burnett County case number 22 CM 122, and you were released from custody, and you intentionally failed to comply with the terms of your bond by committing a new crime by pointing a firearm at another. That's a Class A misdemeanor. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand upon conviction you face a $10,000 fine, imprisonment of 9 months, or both?
I do.
As to count 6, misdemeanor bail jumping, the state would have to prove the same date, time, and place that you were released from custody and you intentionally failed to comply with the terms of your bond by committing a new crime of negligent handling of a weapon, a Class A misdemeanor. Upon conviction, you face a $10,000 fine, 9 months of incarceration, or both. Do you understand what the state would have to prove?
Yes.
Do you understand that the maximum possible penalty, do you understand those maximum possible penalties?
Yes.
Do you understand that with a free to argue as well as any other case, I'm not bound to listen to either side in making my decision? Do you understand that?
Yes, ma'am.
I'm free to sentence you all the way up to the maximum possible penalties for these crimes. Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter pleas?
Yes.
Did you review those criminal complaints with your attorney?
Yes.
In particular, there's sections called the probable cause sections that basically say what happened and why you were charged with these crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Were you loud, boisterous, and indecent?
Yes.
And involved a person of a domestic connection? Family, friend, significant other? And did you know that you were under bail conditions
I do.
and you intentionally violated those when you committed 2 new crimes?
Yes.
Ms. Erdman, may the court use the probable cause sections of those criminal complaints to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or promises to you for you to plead guilty to these charges?
No, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today
Yes.
and voluntarily. Mr. Bail jumping, how do you wish to plead?
Guilty.
As to count 6 in 22 CM 211 misdemeanor bail jumping, how do you wish to plead?
Guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 3 charges. The remaining charges and cases will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. I'm going to turn first to Mr. Klinkhammer, who's appearing and observing this hearing. Mr. Klinkhammer, I want to let you know I have read your victim impact statement, so I do have that, but you're free to tell me anything else you wish for me to consider before I decide what to sentence.
I would just.
So now this guy, Mr. Hardcore, is the victim. He's the victim. Let's go. Oh, it gets juicy.
I would just like it that he maybe get some treatment, some classes, so that he can get better. I know he's old. He's got his own depression and anxiety issues. Maybe jail wouldn't be the greatest place for him.
Jail would what?
Maybe not be the greatest place for him, you know, maybe
Okay.
treatment.
So you're looking at mental health aspect here.
Yeah.
All right, thank you. I'm very sorry. Your impact statement that you wrote and you filed with the court, or that was filed with the court, was very, very impactful. So thank you for that. Any other victims wish to make a statement here today?
No.
And for the record, the court has reviewed the statements that have been filed in the cases. So I'm aware of that. Mr. Renicky, argument and sentencing recommendations.
Yes, Your Honor. In looking at the defendant's history, he does have a smattering of misdemeanors going back to 2006. One of the more concerning ones is an intoxicated use of a firearm. He's got several disorderly conducts, an OWI second, and an obstructing an officer. By pleading to the 3 misdemeanors now in succession, he potentially, if he violates the law in the future, could face a potential enhancement based on the 3 misdemeanors within 5 years if he were to violate the law in the next 5 years. I think it would be, given his age, it would be prudent to have a withheld sentence and 2 years of probation with any and all programming per the Department of Corrections. Whenever someone has mental health or anxiety issues and AODA issues, I'm always worried about self-medication. So I'd ask for absolute sobriety, no use or possession of alcohol, no use or possession of illegal drugs or paraphernalia, regular testing. Because of the multiple disorderly conducts, and one of the disorderly conducts here is a domestic one, I would ask for some kind of an evaluation for either anger management or domestic violence. And then any other programming per the Department of Corrections, no bars, taverns, or liquor stores. And the normal court costs and fees, and then the domestic enhancer on the one count, I think would be appropriate as well. And that would also provide a financial penalty as well. Given his age, I'm not asking for any immediate executed incarceration.
All right. Ms. Erdman.
Your Honor, we would just ask for the year of probation with the conditions recommended by the agent. Mr. Van Domelen is generally pretty law-abiding, other than having some issues with as of recent. He said his last term of probation was quite some time ago. In terms of the need to protect the public, we feel like this would take care of all of the things that are really at issue.
All right, Mr. Von Domelen, do you care to make a statement here today?
Yes.
Go ahead.
I'm under medication now. Full medication. I have a list in my pocket if the court would like to look at what I have to take nowadays. And I just feel much better, let's put it that way. The depression, I never knew I had it so bad. And that's why I was self-medicating. But I take my prescriptions as prescribed. No more, no less. I feel good about myself.
When did you start medications?
Right after the second incident.
He had lost a couple of really close in age friends as well. I mean, I think he went through quite a few things at once, I think. It was kind of a culmination.
I think I remember him saying something of that nature. All right, Mr. Von Domelen, is there anything else you would like me to know?
Basically, no.
Van Domelen. All right. I have heard the arguments of both sides here, and in sentencing, somebody have to look at, one, the nature and the gravity of the offenses. The second, I have to look at the need to protect the public. And the third, I have to look at your character, past criminal record needs to protect you, or needs to rehabilitate you or to provide you with some services. I'm going to tell you, at first glance at these cases, when they first started coming in, they're serious because they do involve, you can see, altercations and a lot of discord in a family, in a family unit. And there's definitely underlying issues here, mental health issues. You present in court, I'm going to say this, that you present in court to be more calm and a little bit more easygoing. I don't get to see what people see behind closed doors. I do have to say that in Mr. Klinkhammer's impact statements, I think he did more than one. It's very extreme. The very different presentation of how he witnessed and saw you growing up and in his life, in his mother's life, versus how you present in court. That he has witnessed some very serious things occur from your hands onto others. Breaking of tables, smashing things, incidents where your wife's fingers were broken.
No.
Well, I can read it where he says that.
Where he says
the things that he has witnessed, and that you have stated that you pulled a gun out on him and threatened to blow his fucking head off. And he remembers the first time you threatened his life with a gun when he was 10 years old, and he was running down the street in the neighbor's house to call the police because you were hitting his mom. And there's a lot of psychological issues because of everything that he's seen and that he's been through as a kid. And I'm going to say perhaps that could be a reason why he is sitting in custody right now with his own serious charges that he's facing. Due to the trauma that he may have experienced and witnessed growing up. Domestic violence is a serious thing. It's not just fights and it's not just aggression between two people. It's two people that have decided to be with each other for life and to take pledges and oaths to protect and to love through sickness and in health, not to create sickness and not to hurt somebody's health.
My wife and I have been together for 32 years. I have never once hit my wife.
Is your wife here right now?
No, she's not. She was here with me every other time. She couldn't make it today.
I presume that this is the victim impact statement for this case. It is filed in this case, and it is stating that Mr. Klinkhammer has observed numerous things.
Yes, my stepson. Oh, he's observed a lot of argument stuff. He's never seen me beat anybody. Ever. I have suffered, my wife has suffered because of what he has done. The money we have spent, putting him through treatment time after time. He can make up what he wants. He will never be, he was at our home, got straight out of prison, came to our home, and once again started doing drugs and drinking within the 2 weeks that he got a job. Then he came home and threatened my wife and me, called her a fucking cunt, a controlling fucking cunt.
Ms. Erdman, he is getting heated now in front of the court, and it is presenting not a very good.
It's not being heated. I'm just trying to tell you the truth.
Am I heated? No. Am I raising my voice? No. And anyone who can hear this, unless it is impacting them in a negative way beyond an ability to control, like it is you here today, is able to hear things and able to say, you know what, Judge, he's not telling the truth. And I'm going to tell you, he's not telling the truth. He can have his own belief of the past and his own fake memories, but he's not telling the truth. But you're getting heated. You're raising your voice. You're starting to use swear words that aren't about this case. They're about other things involving Mr. Klinkhammer. And now you're turning.
Who has been sending my wife threatening text messages from the jail he's in.
And we're not.
I can give you my phone, my wife's phone number. You can call her right now.
That's not why we're here. We're not here to put the blame on Mr. Klinkhammer.
It's not putting the blame on anybody. Everybody's to blame.
Being argumentative with me, and now I am raising my voice. You do not get to speak like this. You do not get to raise your voice to the court.
Yes,
do you understand?
I do. I do.
Then stop. It may not be exactly word for word as Mr. Klinkhammer has recalled it, but I'm going to tell you from just this moment and hearing you speak in court, the time that you were given the ability to do so, you have a problem. More than extreme depression and anxiety, you have severe mental and psychological issues, and you have raised your voice in a very inappropriate, serious way to your family, to the people you are supposed to love. And I believe Mr. Klinkhammer, maybe not exactly word for word, exactly how he has stated that it has occurred. I believe you have done those things. You want to know why? Because anyone who's sitting there at the mercy of the court would not get heated under the collar and start raising their voice. I see a lot of people, Mr. Van Domelen, a lot of people. And a lot of people in situations where they are in domestic arguments and fights. Some are fights and arguments, nothing more. Get charged with things. That's why there are plea agreements. You do have, and you do suffer from, you're an abuser. You're a domestic violence abuser. You are now in front of this court convicted of domestic abuse. And here, Mr. Klinkhammer saying, don't throw him in jail, Judge. Jail's not going to do anything for him. And we have the state and we have your defense attorney saying, Judge, jail is not the key here. But what I don't have is your wife here. Mr. Klinkhammer does say that part of the reason why she has been here supporting you, it's been years and years and years and years and years and years and years that you've been married. And he calls it wife beater syndrome. Not wife beater syndrome, but I'm going to tell you, in the years and years and years that I have practiced domestic violence as an attorney, it is. It's kind of like a Stockholm kind of syndrome. It takes on average 8 to 9 times before a woman will actually, or a man will actually have the courage to try and leave a domestically violent relationship. 8 times. That's a lot. Some never do because they never get the courage. And some have to live through these escalations and these arguments and these throwing of tables and these swearing and these name callings and these injuries that you didn't mean to happen or you didn't mean to cause to her, but they did. They happened. Probation is appropriate. I'm not going to send you to jail at this time, but I am going to sentence you to 2 years of probation. I'm doing an imposed and stayed sentence, not a withheld sentence, imposed and stayed. With regards to the disorderly conduct, domestic abuse, 90 days. With regards to the 2 bail jumpings, the misdemeanor bail jumpings, because they did involve serious allegations involving a weapon, making them a higher level of a safety and wellness concern. Guns, weapons, arguments don't mix. Lethal. They become lethal. So 9 months each. Same incident, so those 2 will be concurrent, but they will be consecutive to 22 CM 122 if you are revoked. Conditions of probation: no use or possession of illegal drugs, substances, or paraphernalia, no alcohol, no going to any bars, taverns, or liquor stores, or any place that has the primary purpose for the sale or the service of alcohol. No firearms, no dangerous weapons, no machetes, no swords, no hunting knives. The court is ordering you to complete not only the domestic violence education group with restorative justice, but you also must complete the alternative to incarceration program with restorative justice. Anger management doesn't cut it. This is not an anger management case. This is a domestic violence case. There's an extreme difference between domestic violence and anger. You don't have an anger issue. You are domestically violent. You must take medications as prescribed. After you complete the domestic violence education group, With restorative justice, I'm also ordering that you do a more intense domestic violence program at the discretion of your Department of Corrections agent. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. $443 in costs and fees per count. You have $500 posted. The rest is to be paid in full within 6 months. Failing to pay in full means you could sit up to an additional 6 months in jail on top of the sentence the court has ordered. You are to pay that money here to the county and not to the Department of Corrections, because I will watch over that. I will make sure that that happens. I'm going to tell you, I had a different feel of this case and these cases when you came, every time you've came in the court before, every time until you opened your mouth here today. Until the real Mr. Van Dommelen came out. If you can't keep yourself contained in court, you certainly cannot keep yourself contained behind private closed doors with people who are there who unconditionally love you. The court is ordering you to provide your DNA. You must do that with the Sheriff's Department before you leave here today. You will be, then you are to go to probation and get probation set up immediately. You are to complete the programs with the restorative justice. By July 28th. You are to contact restorative justice by May 12th. You will get the form that will show what you need to do. In 20 days to appeal, should you fail to appeal within 20 days, you do lose that right. An additional $100 is tacked on to the domestic abuse case for the surcharge. Your $500 will be applied to the amount that you now owe. Mr. Renicky, what is the court missing?
I think you covered it. Thank you.
Ms. Erdman,
That's all you're on.
get your documents. You're free to go to the Sheriff's Department and then go to probation. I am going to do Mr. Klinkhammer's case at this time. Ms. Erdman, can you come and get his documents, please?
On the bottom, it says what you need to do there on the bottom.
We will go on the record in the matter 2011 CF 104 13 CM 361, State of Wisconsin versus Jason Klinkhammer. The state appears through District Attorney James Renicky in person. Mr. Klinkhammer appears by video conferencing in custody at the Bayfield County Jail. We're set here today in this matter for a blessing hearing. Mr. Klinkhammer, you're asking the court to give you leniency with your fines and fees. Is that correct?
Yes, ma'am.
What are you asking?
I don't know. I'm still locked up. I just tried to sell my Jeep to get the $1,500 bond so I can go to the Ruth house, and the person that I had do this decided they're just gonna keep the money and my Jeep. So I don't even have that anymore, it appears. And so I don't think I'll be able to post bond now, and so I'll be stuck here till July at least now. So I don't know, whatever, I guess, whatever you can do, just please don't issue another warrant over the, you know, if you can forgive some of it, or, I don't know, I'm not sure. I just, I
Mr.
know that-
Klinkhammer, no, I'm gonna stop you right there. I'm not gonna issue a warrant. I'm gonna put a stay on any collections of this until a future date and time. We can address this after resolution of your other case. I don't want you to talk about your other case because your attorney's not here to represent you on that. But however that resolves in whatever way or fashion, we can have another hearing to look at your fines and fees and options, okay?
All right, thank you, ma'am.
All right. So thank you. And I will see you, I don't recall your next date and time, but I will see you at your next date and time, okay?
Thank you, Ron.
Thank
Okay, guys. I hope you enjoyed that one. I really hoped you enjoyed that. It was a really good case. I just want to say thank you to everybody. Thanks so much. I'm going to be live tomorrow. And then our big show on Thursday. Let me get in camera. Our big show on Thursday. Credence and Mikey. Guys, make sure you head on over to Irish Demon, Team Skeptic if you haven't subbed to them. Credence and Mikey. And make sure, Miss Fields, way I see it, make sure you go to KCC. She's got TPOs. And she's in her kitchen making something. Guys, you know what the deal is. You have been served.